Good morning, everybody. We see that people are still coming in, but just to have enough time for the webinar and for your questions and the discussion, I think we can slowly start. We are already more than 70 in the room, so I think we can kick off this webinar. A very warm welcome on behalf of the Criminal Justice Platform Europe to all of you. We are very pleased that there was such a great interest in this webinar and that you are all here today with us. This webinar will be also recorded and will be shared later. I think these days we cannot start any professional meeting even without thinking about what happens in the world around us, which is probably something unimaginable or something that we had no in our minds. And of course, the war and the pictures and the news we hear trigger feelings, and very often even overwhelming feelings. But we have to focus on our topic, of course, and we have to focus on our professions and what we can do as individuals, as professionals in this world today, in a world which is really different from what it was a few weeks ago. And I think it also makes us think about our basic values as professionals, but also as individual citizens in Europe and even beyond Europe. And whatever happens underlines the importance of human rights, solidarity, the need for dialogue, and the importance of preserve peace and safety for everybody. And I think these values are not just the most important, probably general values, but also are really connected to our works and all fields of professional life around criminal justice. So with having thoughts about the war and the victims there, and acknowledging the horror of what happens and expressing solidarity, I will move now to the topic of our webinar today. This webinar is organized by the Criminal Justice Platform Europe, which is a collaboration that started 10 years ago and consists of 3 organizations right now: EuroPRIS, the European Organization for Detention, the Confederation of European Probation, and the European Forum for Restorative Justice. My name is Edith Törzs, and I'm the Executive Director of the European Forum for Restorative Justice. We started this collaboration recognizing the need that our sectors work with the same clients, the same group of people, and we wanted to collaborate for different reasons. First of all, to link our professional knowledge and to cooperate to find synergies on the European level, but also to encourage this to happen on the national level as well. We are committed to share best practices to enable a better flow of information and the management of our work and of our clients in a way that different organizations work are supporting each other, and that the clients are treated and helped, supported in a way that is in synergy and leads to the best outcome. We think it is really important to create dialogue between professional sectors, and that's what the Criminal Justice Platform tries to do most of all. And that's why we are really happy to organize events online, but also live events where we have representatives of all sectors: prison, probation, restorative justice, and very often other sectors as well, such as victim support or police magistrates. We find it really important that we don't work in our own bubble, but we know more about how the others work and how we can better collaborate. This webinar is about victims' rights, and we already organized a webinar last July on this topic. That was the first of this kind of webinar, where even for us was not always an immediate answer what victims' rights has to do with the work of probation or prison. Maybe restorative justice is more understandable, but why victims' rights are an important topic for us. And it was clear that there is a huge interest, and I think there is a huge need in our sectors to learn more about victims' needs and how our sectors can support the rights of victims. Of course, the Criminal Justice Platform Europe works on the European level to advocate at the European Union and the Council of Europe for better legislation, for better frameworks for our work. And especially the European Union, but lately the Council of Europe also puts victims' rights as a very important central topic and made a lot of advance in this field, which is really important. Probably you know that the EU adopted its first ever victims' rights strategy in 2020. And our organizations collaborate with the European Union to enable this strategy to be implemented. But we also need to understand that the reality and the needs of victims are not independent from the offenders, and a successful offender reintegration should also think about the victim and what happened to the victim, and what can be done for a successful reintegration and the safety of the whole society between the victim and the offender. The life worth of a victim and an offender is somehow connected through what happened to them during the offense or through the offense. So we cannot ignore this, and we have to realize that, again, we cannot work in bubbles and we cannot work only on one side of the story. Of course, we all have priorities and main responsibilities, but I think this is a time when our thinking has to be more broad and more complex, and that's why we think it is really timely to discuss about victims' rights in prison, probation, and restorative justice. There are also victims with very specific needs, and that's also an aspect that has to be further examined. And another topic that even the EU finds as a specific priority is victimization within detention and the rights of victims who have been victimized in such settings. So I think just to highlight a few of the possible topics that I think our fields have to consider when we are thinking about victims' rights. So after this short introduction, I will give the floor to our colleague Mirka Jakešová, who will tell you some information on this webinar and will moderate it. I wish you a very interesting webinar, and feel free to interact and raise your questions later. Thank you.
Thank you, Edith. Thank you for the opening of this webinar. Hello from me too. As mentioned, I am Mirka Jakešová and I work as a CEP policy officer. Before we start this webinar with our presentation, I have a few announcements for you. The first one is that this webinar will be recorded. So if you know anyone who cannot attend this webinar or if you need to leave earlier, the recordings of this webinar as well as the presentations will be published on the websites of the 3 CGPE organizations, as well as on YouTube channels and Vimeo channels of these organizations. Throughout the course of the webinar, me and my colleague Laura Hein from the European Forum for Restorative Justice, we will share the feedback questionnaire in the chat. We would like to ask you to fill it in. It's really important for us to know your opinion, and of course, it's important for us for our future activities as well. To the presentations, today you will hear 3 presentations from 3 different jurisdictions. Each presentation will take approximately 15 minutes, and the Q&A session will follow after all the 3 presentations are delivered. Throughout the course of the webinar, you can type in your questions to the Q&A chat. As mentioned, me and my colleague Laura from the European Forum for Restorative Justice, we will follow the chat and we will then raise the questions to the speakers. If you have a specific question to a specific speaker, please include it or make it a part of your question so that we know to whom we should address your question. After the Q&A session, the closing word will follow, and this will be delivered by Mr. Gustav Talving, Executive Director of Europris. That's all for announcement, and I hope you will enjoy the webinar. And it's my pleasure now to introduce our first speaker. It's Mrs. Hanna Harnesk from the Swedish Probation, Prison and Probation Service. Hanna is a psychologist in the area of forensic psychology with extensive experience of treatment and risk management for convicted sexual offenders. She has been the project leader for the process of implementing victim protection perspective in Swedish prison and probation. Today, she works primarily with development issues at the Swedish Prison and Probation Services head office concerning risk assessment for sexual offenders, issues regarding honor-based violence, and victim support. Hanna is a frequently hired lecturer in the Swedish legal system. Hanna, the floor is yours. I will just share the presentation for you, and you can start.
So thank you very much for that introduction. I think we can start with slide 2. So if you please change my slide. The UN Convention on the Rights of the Child is now part of the Swedish law. When I began to work with issues regarding safety for the victim, Sweden had ratified the convention, but other legislation was more dominant regarding contacts between the offender and his relatives. I would say that it usually comes down to balancing between 2 sometimes very conflicting aspects of the best interest of the child and what can be considered best according to the child's right to contact with a parent, which has been the dominant perspective in Swedish practice, actually regardless of crime, and the child's right to protection from a parent, which has been a more difficult perspective to regard. Or for female adult victims, it's usually considered a conflict in our system between what's considered the best for the victim regarding safety and so on, and what's in the interest for the offender regarding maintaining relationship that can be beneficiary at release. This is still kind of a core issue for assessment in our prison system. When I came to prison and probation in the late 90s to work with the treatment of men convicted of sexual crimes, I assumed that those who had been subjected to violence of some kind in close relationship were well taken care of during the time the offender served his sentence. That was not really the case. A number of rather serious incidents during visits to prisons or during the time the client executed his punishment made me and a number of colleagues to see opportunities in developing the work around the convicted offender regarding these issues. At the same time, the focus for the security organization within the prison system was primarily on contextual factors such as weapon and drugs. To prevent that weapon and drugs were taken into the prison system, both the security aspects were considered, as well as applicable legislation. To include issues regarding the best interest of the victims of domestic abuse was another matter, and not really consider a high prioritized area related to security work. I would state that these issues were not considered at all or had a relatively low status back then. Next slide, please. About the assignment to protect victims, I initially applied for funding from the Swedish Crime Victim Compensation Authority and was granted money to conduct a minor development work, which meant that we partially reviewed legal possibilities to prevent visits and telephone contacts in cases we consider that it could involve a risk for the victim. At the same time, we took the initiative to arrange meetings between the convicted person and his relatives when and if it was considered to be in the best interest of the victim. Next slide, please. Guiding through this process was the so-called normalization process to violence. The fact that those who had exposed to violence and abuse in their own safety environment have great difficulties in protecting themselves, and the violence gradually becomes a larger part of the victim's everyday life. At the same time, it was still common for the victim to be blamed for the violence. Why does she not just walk away if the victim chooses to support her abusive husband, for instance? Or why did the child subjected to child sexual abuse of her own father not tell if she was doing so badly? And so on. The knowledge back then were limited. Victimology was not really considered in the area of domestic violence. We had general difficulties to understand that victims seldom told what had happened voluntarily, that it could take some time to be able to tell, or sometimes that the child and the victim only told what was proven or documented. Shame and guilt was, of course, always aspects concerning sexual abuse and domestic violence. It has to be considered that this was before the time of the Me Too movement. At the same time, it's important to be aware of that this structure still exists and has to be addressed continuously. Change slide, please. We wanted to turn the perspective, to shift the focus from the victim to the offender and increase his opportunity to take responsibility for what he has done. This can be viewed as a restorative justice aspect of prison work. We soon noticed that time in prison was well suited to handle difficult meetings of various kinds. As you can see in my slides, there were great benefits for all parties. The victim got the possibility to meet the offender for questions, reduce fear, and so on. And the offender got an opportunity to take responsibility for his previous behavior. During the work, lawyers have been my main partners, working with the legislation issues to bring about a new case law that provides a framework for the boundaries has been absolutely crucial. We tried a number of cases in the higher legal instances like the higher Swedish court, and when we could help to develop the psychological reasoning for the legal system, it was easy for the administrative court to rule in the favor of the prison service. In fact, we were right in all the cases that we tried during this period of time. After a couple of years, Swedish Prison and Probation Service received an award from the Ministry of Justice for this project. Next slide, please. I brought some cases to demonstrate the work. The first case was actually one of my own first cases. I prepared the meeting for a long period of time. The case of Richard involved a mother whose daughter had been killed by her former boyfriend at a pretty young age. I think she was around 20 years old at the time. The crime was committed in a connection with the separation. During the court hearing, the mother perceived her daughter's former boyfriend emotionally turned off and cold. That kept her wondering for years. What had really happened that made this young man, that she earlier perceived as nice and generally warm, a sudden killer? Next picture, please. The victim was found undressed at the crime scene, which made the victim's mother wonder what had happened prior to the offense. She wanted badly to confront the offender with some questions, and she was keen to get some answers. And for that, she understood the importance of professional help during it. It was important for the mother to take control of the ending of their contact, and she declared quiet during meeting that she wanted no further contact with after his release. So what I want to say about this case was that the long contact with the victim's mother in preparing the meeting made me aware of that even when an offender can give his explanation on what's really happened or give his detailed information about his reasoning for offending, it can never really give the victim an acceptable reason or explanation to why the crime was committed, but can be still of a great importance to meet and address the circumstances regarding the crime. So if we change slide to case Sven. Case Sven is an elderly Swedish man with a massive criminal record for sexual offending behavior against young girls. Sven's case demonstrates the importance of a victim protection perspective according to risk assessment as much as for the victims. In this case, Sven's granddaughter's best interest. Sven had committed sexual offenses against a number of girls in his close surroundings, such as his own daughter, foster child, and now granddaughters. Sven never received treatment for his offending behavior for over the nearly 50 years that he was active in criminal conduct. Due to a number of factors such as lack of motivation from his part, poor structure to encourage the principle of risk, need, and responsivity, which is a successful principle in terms of risk management and priority. During his last sentence, Sven became very sick due to cancer. I think the awareness that he would soon die made him to take some step towards responsibility for his actions. That resulted in a meeting with his latest victim just a couple of days before he passed away. The victim returned after many years to our staff members and told the importance of that meeting. Sven's constant relapse and re-offending was a consequence due to a combination of factors, such as his chronic deviant sexual interest for children, his constant access to victims, which in part was due to his likable and trustworthy personality traits, and the fact that his family dynamic was extremely denial of abuse. Next slide, please. Over time, and as the Swedish government decided to invest in the area of domestic violence, the work method was spread. Today, it is a routine to consider the best interest of crime victims in all cases involving domestic violence, sexual offendings, and/or honor-related offenses. The pioneer work in participating and controlling meetings between offender and his family members, sometimes victim of offenses, is now a nationwide perspective in the organization. The best interest of the victim are always taken into account in decision concerning a convicted person throughout his time in prison and probation. The longer and more difficult process that include conversations of more therapeutic nature are more limited to the treatment and the work of psychologists. Last slide, please. Thank you for listening and thanks for your attention.
Thank you, Hannah. Thank you for this very interesting presentation, which you delivered. I personally have a few questions on you, but I will leave it up for our Q&A session. I can see that so far we have no questions for you, even though our Q&A session is in 30 minutes. You can type in your questions right now and we will address them later. And now it's my pleasure to introduce our next speaker. It's from the Czech Republic. Mr. Adam Styx is a graduate of Masaryk University in Brno at the Faculty of Law. He works as a probation officer in Prachatice Regional Center of the Czech Probation and Mediation Service. He specializes in the agendas of community service and mediation of conflict resolution in the pretrial proceedings, where he works with both offenders and victims of crime. His aim is to apply and promote the principles of restorative justice as much as possible. Adam, it's yours.
Thank you, Mirka. Good morning, everyone. Thank you for the invitation. I will just share my presentation. I hope that everyone can see it in the full screen.
Yes, we can.
Thank you. So, good morning. I would like to briefly mention the development and the current situation in the victim support system in the Czech Republic. And then I will talk about the probation and mediation service and our work with victims. So let's get started. Before the implementation of the European Union's Victim Directive, the Czech criminal justice system was primarily offender-oriented. The victim, from the optic of the law, was considered more of as a party to the criminal proceedings, rather than a person with specific needs. Similarly, the law enforcement agencies focused solely on the punishment of the offender, and the witness remained overlooked as a mere witness to the crime. That is not to say that the state didn't care about the victims at all, but the great share of work with victims was done by the non-governmental organizations. This has changed with developing legislation of the European Union, partly with passing the so-called Victims Directive, which main goals were to set standards of victim support, strengthen the position of the victim, and ensure sensitive treatment. The member states had to transpose the directive into national law by the November of 2015. Czech Republic transposed it into the Act on Victims of Crimes, which came into force on the 1st of August 2013. I would say that the subject matter and the principles of the directive were met in this act, and the goal to create comprehensive assistance to the victims from both the state and the non-governmental organizations was fulfilled. I will talk about how some of the principles are applied in practice a little bit later. As you can see, the subject matter of the Act can be divided into three parts. The first is the catalog of the rights granted to the victims. The second part regulates the institute of financial aid for victims from the state, the range of applicants, the conditions that have to be met in order to award the financial aid, and the administrative process itself. The last part addresses the relationship between the state and the organizations that provide help to the victims. The victims that are accredited by the Ministry of Justice to provide help to the victims can be divided into four categories. The first two, providers of social services and providers of legal intervention, often overlap because one organization can be qualified to work in both of these areas. The third category are lawyers. There are over 480 lawyers in the Czech Republic who provide free legal assistance to the victims, but only to the limited extent. The common practice is that only the first only the first consultation with the client is for free. I tried to use the register and find out the providers of victim support in my area. And I found out that in Prachatice region, there is one provider of social services, two organizations that provide legal information or restorative programs. And out of the 480 lawyers, 17 of them provide their services in Prachatice region. But only one of them has the office right in Prachatice. The fourth category consists of centers of the probation and mediation service, which I will talk in the next part of the presentation. If I had to sum up the current situation with the victim support system, I would say that it is continuously improving, and I hope this trend will continue. But it is important to say that a large share of work is still done by the non-governmental organizations, not only those accredited by the Ministry of Justice, but even those that are regulated by the Act on Social Services and funded by the Ministry of Labor and Social Affairs. Like I said, the situation is getting better and better, but there is always room for improvement. I will now try to mention four, in my opinion, most serious flaws in the system. The first one is availability of the services, which differs from region to region. The centers of the non-governmental organizations who provide help to the victims are in the bigger cities, which is quite logical. There's more people, more potential victims, better logistics, and so on. But in some, particularly socially excluded areas, the care is still lacking. If I have to talk about our region, I would say that the availability of the services and the cooperation is at a good level. We work with local charities, asylum homes, low threshold centers, and others. The same applies on the cooperation with law enforcement authorities. We have especially good relations with prosecutors, who often authorize us to work with victims. This third problem is related to the administrative process of awarding compensation from the state. The purpose of the financial aid is to bridge the aggravated social situation of the victim caused by the crime. And in order to fulfill this purpose, the financial aid can be awarded even before the offender is convicted. However, in practice, the Ministry of Justice and the Department of Compensation is often reluctant to decide on a request before the judgment is given, and they fail to meet the 3 months time to decide on the request. So the victim is often awarded the compensation after 5 or even 6 months after the application has been submitted, which is totally inconsistent with the purpose to quickly help the victim to overcome the negative consequences of the crime. The fourth problem and the most common deficiency is, in my opinion, the scope and way of informing the victims about their rights from the police. The obligation to inform the victim about her rights in details is mostly fulfilled at the police station after the victim gave a statement. And that is a moment when the victim is hardly able to perceive any information. Information is usually very long, as you can see. Those are 3 or 4 papers of information which are in legal language, that is for people who are sometimes in shock or stressed, completely unintelligible. That is something that I encounter very often in my practice. The victim comes from the police, where she signed 3 or 4 papers of information, but in reality, she doesn't know what her rights are or even what is going on in the criminal proceedings. Now I would like to talk about probation and mediation service and its role in victim support in Czech Republic. Probation and mediation service is subordinate to the Ministry of Justice. We have a center in each district of the Republic, so altogether 74 service centers, which make the services available and accessible for everyone. Here you can see the general overview of our activities. We can divide them on probation tasks and victim tasks, but they are closely connected in most times. I will focus on the second part, which are the victim tasks. When we are assigned a new case and we know from the file that there is a victim, we always contact her with offer of cooperation. The first contact with the victim is very important, because on one hand, we have to explain her who we are, what we do, what are the possible benefits of the cooperation, from the cooperation for her. But on the other hand, we don't want to overload her with information and confuse her even more. So it is upon the decision of the probation officer which way of contacting the victim he chooses. I prefer the phone contact because I find it more flexible. The victim can ask additional questions and we can schedule a meeting right away. As you can see, in 2021, the service center started cooperating with over 4,000 victims. The crime victims can visit or contact any probation and mediation service center regarding of their residence. All probation and mediation workers are trained in crime victims assistance. Part of the education course of officers focuses on the communication and other soft skills, leading to professional interview or and mediation. I would like to add that it is easier for the victim to comprehend the information here at our center than at the police station, because the environment is much safer, comfortable, and we have more time to spend with the victim, listening, explaining, and providing psychosocial help. In appropriate cases, we can recommend cooperation with non-governmental organizations that provide further help to the victims, or even some professionals like psychologists or attorneys. We can help victims with reporting the crimes, but before doing so, we carefully explain what they can expect. Of course, what are their rights, what are the steps in the criminal proceedings, and what are the possible outcomes of the whole process. These are the, I would say, most common activities we do with the victims, apart from providing legal information. We help the victims to file and gather necessary documents in order to claim the compensation from the state. Sometimes we can help them prepare the victim impact statement. Last year, I had one client. He was a victim of a car accident. And we discussed the possibility of arranging a mediation with the offender, but it became obvious that he wasn't mentally prepared yet to meet the offender. but he wanted him to know what impacts the car accident had on his life. So he wrote down in detail all of the negative consequences and his feelings. And we sent the victim impact statement to the court when it was later used as an evidence. By far the most common activity we help victims with is the compensation for damages in criminal proceedings. We help them to file the claim so they don't have to file it later at the civil court, which costs additional financial and financial costs. It is important to say that we work with victims regardless of the stage of the criminal proceedings. So even in pre-trial stage, we often try to start the process of the mediation with the victim if there are the conditions to arrange the mediation are fulfilled. So the cooperation with the victim often starts in the pre-trial stage and then continues even after the post-trial stage. It is important to note that the judgment of the court is not an obstacle for the mediation to happen. So if we have consent of the both parties, we can prepare a mediation, which is an out-of-court settlement of the conflict between the parties. In 2020, the Probation and Mediation Service carried out 471 mediations. 48% of those, so almost one half of all of the mediations, were cases where the offender committed a crime or of bodily or grievous bodily harm by negligence. I would assume from my personal experience that those were cases of car accidents. I would like to point out that most of these mediations aren't the typical mediations, as you might know. There are often just a meeting of two people who need to share their feelings and express their feelings towards one another. So the role of the mediator in these cases is less active. We try to hold back and let the process naturally flow. It goes without saying that we work with all kinds of types of victims, regardless of their age. We work even with children and juvenile offenders. Maybe I will add that the agenda of work with youth has some specialties, but I don't want to go into detail because I don't have much time left. So I will move to the last slide. That is a case study I prepared to show you step by step how we work with a victim. This case which is still ongoing, is a case of 23-year-old woman who is a victim of domestic violence. Her partner, the offender, abused her for about a year, and the attacks escalated gradually, both in frequency and aggressivity. In the end, he assaulted her even 4 times a day in a very brutal way. Fortunately, one day she ran away and reported everything to the police. The offender was taken into custody, and the Probation and Mediation Service was authorized by the prosecutor to enter the case and take care of the needs of the victim. We discussed it with the colleague, the case, and we decided that it would be better if my colleague, who is a woman, would talk to the victim for her to make it more comfortable. So I was just helping with preparing the legal documents. My colleague at first contacted the victim on the phone. and she gave her general information about our organization, about the possible cooperation, and they scheduled a meeting. At the meeting, at first, the victim received further information about the criminal proceedings, what she can expect, what are the possible steps for her in the process, and then they talk about the crime itself. Usually, when working with victims, it is better to let them talk, don't interrupt them, don't ask questions about the crime, but rather ask questions about their feelings, their emotions, and so on. We use different methods or techniques when talking to the victims. One of them is called mirroring or a reflection, where we try to mimic the verbal and non-verbal behavior of the victim. For example, the volume or intonation or tempo of the voice, in order to help the victim feel safer. The specific outputs of the cooperation with this victim were, as you can see, the application for legal representation free of charge, because it is a case of especially vulnerable victim. Then, because my colleague during the interview found out that the victim is very scared of the offender, even when he is in the custody, so they decided to file a request for a restraining order in case the offender is released from the custody. And the last output from the first meeting was the arrangement of contact with crisis center. That is all. On this last slide, you can see the poster from the project of European Day of Victims of Crimes, which took place on the 22nd of February. And on the right, you can see our workers with police who are honoring the victims of crimes by minute of silence. This project was part of the raising of awareness about the victims and to work with them. So that is all from me. Thank you for your attention, and I'm looking forward to your questions.
Okay, thank you, Adam. Thank you for your presentation. You can stop sharing now. Okay, we already have some questions for you. I can see that some of them are very complex, and we will address them right after. Now I can see that Levent is ready to deliver his presentation, so I will introduce Levent. It's my pleasure to welcome him here as well. Levent has been Executive Director for Victim Support Europe since 2014, and in that role he is responsible for providing overall leadership, strategic direction and management of the organization. Levent began his career in 2001 in the UK Ministry of Justice before moving to the Home Office and the Cabinet Office under Prime Ministers Blair and Brown. Having previously worked in the European Commission for 3 years, Levent returned in 2009 to work as a national expert tasked with writing an EU directive on victims' rights. Over the next 3 years, he developed the European Union's policy on victims' rights, leading the development and negotiation of the EU directive, which establishes the minimum rights for victims of crimes. He also worked and spoken extensively on victims' rights across Europe and globally, providing expertise to national governments as well as the United Nations, Council of Europe, European Union. He helped to found Victim Support Europe sisters organization, Victim Support Asia, and most recently is leading the consortium delivering the work of the European Commission's EU Center of Expertise for Victims of Terrorism. So, Levent, it's yours.
Thank you, Mirka. Remind me to send you a shorter bio. I think the bio is longer than my speech. Good morning, everyone. Good to have you all here, and it's fascinating discussions. I was part of the discussion last year as well, and I have to say, when I was thinking about what I need to be speaking about, I always come from the position of what on earth can I tell you as someone who is not from the probation and prison service. So this was a challenge in itself. Can you see that, or am I showing the wrong screen there?
We can see two screens. You have to change display settings.
Okay, let me just do that then.
We still can see both.
Yeah, it's not giving me the option.
Screens, but it's readable. So.
Okay, I don't. It's for some reason it's not showing the option to switch screens as it did before. Okay, well, we carry on. So that was my thought. Just a quick introduction to Victim Support Europe. We're a network of 66 members in 32 countries. Those are primarily victim support organizations from civil society and from government, and they support somewhere in the region of 2 million plus victims each year. What we do as the network is we really work on policy, advocacy, capacity building, training to ensure European international laws are established for victims of crime, and to ensure that those are implemented and services exist across Europe and globally. So when I was thinking about what on earth I need to try to talk to you about, I suppose the starting point was really what actually are the legal obligations on prison and probation services, and you've already heard a little bit about that in terms of the Victims Directive. And I think that gives you a good understanding of the minimum that would be expected from a prison and probation service. But then there's the question of, well, how to do that, and can you go further in terms of those obligations to do more for victims, even though they may not be legal obligations. And really, when working that out, the way I see this is in what are the points of engagement? In which ways are you coming in contact with victims? And you have this idea that there are victims of prisoners. There's of course victims who are in prison. So people either victimized within the prison system or who were previously victimized before they came into the prison system. And then there are family and connections with victims. So that's a fundamental aspect of working out this role. But there's also the question of how you are engaging with prisoners themselves and what influence you have over them, and also who your partners. And I think these are fundamental questions which when reviewed together helps answer the question of what the role is. And if we start with that first issue, then really when we look at legal obligations, it's important to know what those legal obligations are, but it's also important to understand that they are driven by victims' needs. So the legislation that's in place at the European level is organized and created in accordance with the victims' needs. So it's essential to understand what those needs are. And I've put them here. I explained it previously what those needs are. So I'll just be brief in terms of explaining them. So this is how VSE sort of visualizes the needs. This is a summary of the common needs of all victims of crime. And that starts with respectful treatment and recognition, which is a sort of a broad concept in terms of recognition. It means recognition as a victim, but it means also the way that victims are treated. And that might be manifested through laws that are in place, memorials. It may be the way that a compensation system operates. Then they have the need for protection, which covers physical protection needs from further violence from the perpetrator or other perpetrators, but it's also protection from secondary victimization, protection from harm caused by our interactions with victims. Then we have support, and there's a wide range of support needs, from information through to emotional, practical, administrative support, legal assistance, and more. Victims also need access to justice and participation within that justice system, and they also need compensation and restoration. And that gives you the broad understanding. If you know all of these needs, then you can review your engagement with victims and others to understand what is your role in terms of ensuring that those needs are met. And then when we see that from the legislative perspective at the European level, there are somewhere in the region of 8 European laws which have a specific focus on victims. and they will either focus on certain groups of victims, such as focusing on child sexual exploitation or human trafficking, or they will cover cross-cutting issues which are relevant to all victims. So there are two pieces of legislation on mutual recognition of protection orders. There is an overarching directive for all victims that establishes their rights and obligations on states. So those are cross-cutting in nature as well. And this year, we're anticipating probably next week that there will be a new legislative proposal on gender-based violence. And we're anticipating multiple updates on existing laws, as well as potentially a new Eurocrime in the coming years on hate crime. So there's a lot of movement there. New obligations are being established in different settings, and that's at the European level. Then we have at the Council of Europe and UN level, different obligations are also being established, or commitments by the member states. And then when we dive in detail, I won't go into these because they were already set out within the context of the probation and prison services earlier, but we have the EU Victims Directive, and we can see there that the directive is organized in terms of these primary needs. And the key approach is to look at those obligations and those rights, and to see again, in what way do the prison and probation services have a role in ensuring that those rights and needs are achieved. And I suppose part of the question really is to what extent can those services be involved, and to what extent should they be involved, and who should be leading and who should be supporting? And those are fundamental questions when we're thinking about the coordination of these responses. The reality is that there are scarce resources, scarce funding. You all have significant amounts of work to do, and there are important prioritization decisions about the ways in which you get involved in addressing the needs and rights of victims. And that will be an important aspect of that decision making, is really understanding, okay, what are all of these rights? And then in what way is the prison and probation service best placed to ensure that those rights are met? So just as an example to see that, and I think this is reflected in the previous two presentations, in what way might those rights be reflected in the work of prison and probation? And we see, and we heard earlier about the helping victims to report crime, identifying those victims. If you are engaging with prisoners and you are finding out about potential situations where they are planning or have carried out further crimes, for example, maybe within restorative justice processes or within any other kind of engagement with victims and perpetrators, you find out about other situations where the victim is not being recognized or where there's other crime situations. And that will follow through in terms of identifying risk to victims from further harm. Maybe there are threats, maybe it's coming up to the release period, and there is a need to understand what are the risks for victims. And the question is, well, what is in place and what is organized to identify those kinds of risks? And this follows through with secondary victimization. How are you as an organization engaging with victims? Is the way that you do that, and as you as individuals, is the way that you do that harmful in any way? Can it be done better to avoid secondary victimization and to understand victims? So there are many different ways in which during your engagement and your primary operations, you may have an opportunity to either harm or help victims. And if you see there, for example, even if the trial will have been completed, there may be appeals. Those appeals may happen years later, and there may be ways in which you can support the information that's provided to victims, the way that victims are able to be heard. It's not to say that you should be, I think that's part of the discussion on coordination, is even if you can do certain things, should you do it? And how should you do it in a way which is coordinated with perhaps other lead actors? So I suppose the fundamental question when it comes to coordinating all of this activity is, how do you ensure that success, and how do you ensure it's not just random luck? It's not ad hoc behaviors, or maybe it's done in one prison but not in another prison. It's in one part of the country or not in another. I think for most prisons, I suspect for all prisons, victims are not the primary concern. So that's a challenge when you're trying to work this out, but they're not the priority in terms of your work. Well, then how do you design your solutions in a way that it is easy to take into account the needs of victims and make that operational? And the other question is, well, how do you organize your services so that you have enough knowledge about victims' issues to make those decisions? And so that you can engage with those who work with victims, your partners, so that you can benefit from all of their knowledge and make your decisions, but also so that they can benefit from your knowledge. And that process of engagement is fundamental to helping make these decisions, but also then helping others to adjust their activities so that you are working in a mutually collaborative way. And then how do you transform that into specific action at the individual level? So I think what this really comes down to is, and in terms of achieving change, is at the three different levels. It's the level of leadership, it's structural change, and it's about personal change. Victim Support Europe, we've produced a national victim support framework, which somewhat mimics these concepts. And effectively what we're saying is that achieving victim support and victims' rights tends to be a start-stop process where politicians and others get interested, lose interest, movement happens at one point and then stops. We see that there are multiple actors involved or can be involved, and they're not necessarily coordinated, but fundamentally there are multiple entities which have a role in delivering support. So what we have said in the context of that national victim support framework is that you need a long-term strategy. And that really sets out the vision and the long-term goals to ensure that we don't have this start-stop nature in our work. But you also need to have a national coordinating body. You need to have a mechanism, a committee of some sort, which brings together governmental and non-governmental actors, which includes probation and prison services within that, so that they can have strategic discussions about how they need to be organized and coordinated. And so that they can work out, well, which entities are best placed to deliver a certain kind of service, who should actually be leading on delivering support services, who should be supporting the delivery of such support, rather than each entity deciding this is what we're going to do, going ahead with it, but then now you're competing for budgetary resources with other organizations, or you're not actually coordinating that delivery so that victims and organizations don't know to whom to turn. So that strategic context is fundamental at the national level, but then that gets translated within the organizational level. So it's about ensuring that at the leadership level, there is a vision and a strategy for the organization around how to address victims' needs and rights, and then work out from there what is the commitment and the organizational change that needs to be made. And that commitment will translate into the structural and personal change. And the structural level is, well, what are the rules and procedures that need to be in place so that, as I said earlier, it's not just random luck that you discover a victim is in need of help, or that you discover that you're not communicating with victims in a correct manner. So the infrastructure is put in place, you establish those coordination mechanisms, you have the systems in place so that, as you saw with the situation in the Czech Republic, you know who are your key partners, in your location and nationally, and you don't just know who they are, you get to know them, so there's a level of trust, and then you build from there coordination mechanisms, memorandums of understanding. Maybe you actually establish information coordination. You may even be able to share information structures between organizations or have connection points. So there are fundamental ways in which you can look at your internal structures and your engagement points with other organizations. And you can see where you can achieve joint working, collaborative working. You need to know who is doing what and where, so that you don't have competing activities, but actually supported activities. So if you take something like the victim impact statement, which was mentioned earlier, well, who is carrying out a victim impact statement, or who is helping a victim to do that, and who's actually best placed to do that? Is it a victim support service? Is it the police, or is it yourselves? And then through that, recognize who's the lead and who helps make that happen as a consequence of the knowledge and engagement that you have with the perpetrator and with the victim themselves. And then we have the change at the personal level. Each one of us can make a difference. And first of all, that starts by recognizing what that role is and making the commitment to change. And then it's about developing that knowledge, the training, knowing what the needs of victims are. Because again, there will be your minimum legal obligations. You have to inform victims where they've requested it and where it's part of your legal situation. You have to inform them of the release of the offender. But how do you do that is fundamental. So it can be done in a very standard form. A letter is sent out, but if you are, if the victim and the perpetrator live next to each other, and the perpetrator was stalking that victim for many months or years, a letter will cause significant harm to the victim, and the timing of when that letter is sent. So in some services, you have victim liaison officers, certainly in some prison services, who actually have that personal engagement. And that's the recognition that this minimum information is not enough, because you will fail in terms of your other obligations towards victims, in terms of secondary victimization, in terms of respectful treatment, for example. And if that's not in your service, you as an individual can recognize that if you know what the rights are, what the needs are, and you can change both yourself, but you can change upwards the structures and the hierarchy as well to achieve that. So just to look at this from the perspective of communication and information, we have these rights for victims, and it's not necessary. Most of these will be implemented by police services. But the question then is, well, what again is the prison and probation service role in doing that? And these are the sorts of questions that we would be asking ourselves. Well, what is the information that's provided and in what form? So how can we coordinate that? What is the timing of it? To what extent are we more in touch with victims than others? Or is it simply that we need to engage with another service? Do you know, for example, if victims that you are in touch with are receiving support from another organization? So is it better that the guidance and information is provided to victims through that service rather than your own service? Or do they have no engagement? And this is all about referral. Do you need to get those victims to be aware of the services that are available to them in order to better inform them of that? Or is it that you need to be doing all of that? And how have you organized that system? So these are fundamental questions, but it starts from this strategic perspective, rather than simply seeing there's a problem with this individual case, let's find a solution. It's equally important to have the strategic perspective to say, okay, we're going to look at our service as a whole, and we're going to see where we fit within the wider national context. And then we're going to organize ourselves to address all of these different needs over time. So that hopefully gives some idea, at least our perspective, of how coordination can be achieved and some of the challenges and risks. It's based on me not knowing a huge amount about the prison and probation services, but I think often the way that any of these services work is similar, and the questions that need to be asked are similar. I think that's where we can have the greatest opportunity for change. Thank you.
Thank you, Levent, for this presentation. I would now like to ask all our speakers to come back, and my colleagues, so that we can start with the Q&A session. I can see that we have some questions which we will address. Please don't forget to fill in the feedback questionnaire. I already put a link to the questionnaire to the chat. And to start with questions. The first one is for Adam, and it's from Poland. Alena Zajac is asking whether probation officer can also be an official mediator, because in Poland it's not possible, and as these are two independent functions. So if you can quickly elaborate on how it works with mediators in the Czech Republic, Adam.
Thank you for that question. To answer it, yes, he can. The probation officer, once he passed the course of the education and the final exam, he's qualified to lead a mediation. Probation officers in Czech Republic are the only ones who can carry out mediation in criminal cases. So we do either probation and mediation, both activities. But oftentimes the probation officer who leads the mediation is different from the one who is handling the case. So we cooperate with each other, but in order to stay impartial throughout the whole process, the probation officer who carries out the mediation is different from the one who is handling the case. So the answer is that yes, he can, but he has to pass the education, which is around 300 hours of probation block and legal block. Yeah, I hope I answered it understandably.
Thank you for this. Mrs. Valentina Bonini from Italy, she shared with us then that in Italy, and I would say it's not just Italy, it's many other countries, they have the same problems on victims' right information, which is given by the police, mentioning that it's long, it's complex, in legal language, which is very often ununderstandable for the victims, and they highlight the pivotal role of the victim service. There was the question, I believe it was for you, Adam, but I believe it was answered that regarding access to justice, are victims provided with legal help from the side of the probation and mediation service? I guess yes, right?
Yes, they are. They are provided with the basic legal information, but concerning the especially vulnerable victims, they can be represented for free if they request for it. Other victims can be represented for free too, but they have to prove or demonstrate that they have insufficient funds to be represented. So the process is very complex, and they have to demonstrate and show their incomes and other documents. So to get legal representation for free is very hard in Czech Republic, I would say.
Thank you. I can see if we have any other questions. I personally have a question for Hannah. I would like to quickly ask how many meetings between offender and victim on the case of sexual abuse and domestic violence, and well, the other cases, how many meetings are held in a year?
Oh, we don't really have any statistic actually on that, and it can be also very different kinds of meetings. It can be more like strictly supervised and controlled based on like more security security aspects. And then we have this more of like a long-term therapeutic nature kind of meetings that involves some kind of treatment. We have like 1,500 convicted sexual offenders yearly, and I think in I don't have an exact number, but it's working in a large prison for sexual offenders. There is usually some kind of questions regarding questions of victim. That doesn't necessarily always result in a meeting. That's like kind of the information I can give you on that topic.
We then have a reaction from Germany from Mr. Stefan Trier. It's for you and for Adam and Hannah. Stefan is sharing that in Germany they have an established probation service. However, victim offender mediation is left to neutral social services because they believe that the probation service shouldn't carry out victim offender mediation because it's too much oriented toward offender. This is the part where Levan can provide us with his experience or opinion as well. Can you all quickly tell us how you kind of perceive this? Or
who do you want to go first?
If I can just say something quickly on this, meetings between the offender and victim is more in our system a question within the closed system of prison. In probation, we deal with these kind of issues more outside of the context of meeting and mediation. So that's more like the German model. It's more of a question for social welfare once the offender leaves prison. But it can be extremely helpful to have dealt with certain issues during the time when the offender is incarcerated, of course. He can't do any real harm, and a lot of practical issues can be dealt with before coming to these more emotional topics.
Levan, can you?
Yeah, I mean, it's a really important point. I think part of it depends on the organization of your system in your country, but I would say as a starting point, there's always this risk, there's always this concern, and we say this about restorative justice as well, and who is responsible for taking it forward and pushing it, and how do you achieve a balanced approach to that? How does the victim perceive it if one sort of organization or another sort of organization is responsible for making that restorative justice happen? I think that there's probably 2 or 3 aspects to this. One is that it's really important for there to be choice for victims and to have different avenues to access those services and restorative justice. And I suppose there's a realization that if you don't have probation and prison involved in some way in delivering that kind of service or making it happen, let's say, then you will have victims who don't have access to restorative justice. And there was an example given by our president, Jerry Hanna, where there was a victim who wanted to meet the offender who was in prison, but there were no restorative justice services in place. And it was only in a way by luck that she knew the head of the prison service, that particular prison service, that something was organized. And that's that point about it not being random luck or who you know that should result in the need being met. So there's a need there. The victim wants to engage with an offender. That offender is in the prison. So then you have to work out what is the role of the prison service in helping make that service happen. And then you need to know what are the principles by which it needs to run and the risks of the involvement of that service. and then you can address it. So there are certainly all sorts of risks that it's driven by an offender perspective, that the victim may have to go into a situation which isn't safe for them. But if you identify those risks and understand who might be best placed to minimize those risks and achieve the objectives, then you can make good decisions about what will be the role of the prison probation service in making restorative justice happen. But if they're not involved in any way, then you're going to have a whole group of victims who will probably never have access to restorative justice, but who would like it.
Thank you, Levin. We have a reaction from another German state mentioning that it's not the same in every German state. In Bremen, for example, they provide assessment for minor domestic violence cases, and they built now up colleagues who get trained in psychological process support. Unfortunately, we are running out of time, but there are still questions. Maybe this could be the one, but for Levent, which should be the main common issues for training prisons officers, probation officers, and providers of restorative justice program regarding the needs of victims. In the meantime, I can see that there is one question for Adam. Adam, do you think it would be possible to respond this question either via chat or now or after Levent? Okay, so the question, is it possible to say what, I'm sorry, we can't.
So me or Levent?
Okay, you first, Adam. Is it possible to say more on what kinds of restorative practices are used in spite of victim offender mediation?
Okay, so at first we need to identify the needs of the victim and the motivation of the accused. And then we evaluate if the case is suitable for the mediation. And other important thing is if the solution can be found during the mediation. So if we see that the expectations of the parties cannot be met during the meeting, the mediation usually won't happen. Other restorative practices, we use different methods of communication, both with the victim and the offender. And usually the best way to arrange the mediation is then we talk at first with both of the parties separately. And then at the start, we tell them what they can expect, how will it be going. And then it is best when the victim can speak as first and say their feelings. Then the offender can react to it, and then we can find a solution together. Sometimes we had once mediation where both of the parties started screaming at each other. So it was the best solution was to stop it, then talk with them separately, and then try again to reach the conclusion. But for other restorative practices, I could talk about restorative programs we use sometimes before we offer the offender the mediation, but that would be, I think, for another 10 or 15 minutes.
Okay, thank you, Adam. I can see that Levan is in, so can you share with us your opinion?
Sorry about that. The cursor wasn't working. I would say I would split it between training on sort of legal issues and then soft skills. So I think you need to know what are the laws, what are the obligations. You need to know what are the needs of victims and what's the impact of crime on victims, because that really gives you your foundation for then using your own personal analysis of a situation. and not simply relying on factual information, but actually having an analytical process to your engagement with victims. And then I think that there are these fundamental soft skills around empathy, which means putting yourself in a situation where you can understand the position of the victim and also the offender, and from that be able to take appropriate actions. So empathy is fundamental. Effective communication, and we talk about the information provision. Well, communication is written, oral, and multiple other forms. It's understanding how to communicate, what are the different ways in which we need to communicate, and then how to do that with victims. And it's not just about the way that you speak, but it's what might be harmful ways of communicating even, or what might be helpful, or how do you achieve simple and accessible communications with victims. I think part of what's helpful if you really get into more in-depth training is things like cognitive behavioral therapy, which also help you understand how you think as a person and what your personal belief systems are and biases are. When you understand yourself better, then you understand where others are coming from and how to engage with them. And I would add as a final point, self-care. I think as prison and probation officers, you're all engaging in an environment which is pretty harsh normally, I would imagine. I've not been there, but that's what I understand it to be. And that can cause trauma for yourselves. And if you're not looking after yourselves, you can't look after others. And so I think that should be part of training and the understand. And when you connect all of these bits together, then you understand how to look after yourself. Then you understand, well, those same sorts of things are equally important for victims. And if you understand how to do it for yourself, you understand better how to do it for victims. So it just becomes something of a virtuous circle.
Thank you, Levent. I would like to apologize to Sandra. We have one more question and we will respond this question in email. Thank you all the participants for your presentations. As mentioned, we would be happy if you can fill in the feedback questionnaire, which I'm now sharing again with you. And I'm inviting Mr. Gustav Talving to close this webinar.
Thank you, Mirka. Good to see you all. We're still close to 100 participants, so I will take some time to wrap up this webinar. Well, to me, it's quite obvious that victims' rights is one of the common factors that are bringing together prison and probation services, victims' rights organizations, and not forget restorative justice approaches. I find this very interesting, and to me, sort of getting more knowledge about restorative justice and how this is sort of linked to our services is a very interesting journey personally, but also I think we have a lot to learn from these approaches, bringing all these perspectives together. I will use the previous presentations as stepping stones just to brief summarize the webinar, starting with Levent's presentation, him saying that there are many opportunities to either harm or help victims for prison and probation services, and that's very important to keep in mind, I think. He also stressed the need to clarify roles and responsibilities within a national framework to support victims, and sort of where to fit probation and prison services into that framework. And moving on to Adam's presentation, I think the Czech Republic showed a good example of how this can be done, making an inventory of existing support structures and organizations, and also the resources for this, and sort of focusing on the multi-agency responsibility for victims. And he also presented an interesting concept of probation service support centers, which is clearly, as you've seen in the chat, is sort of being received differently in different countries, of course, whether the probation service or prison service should involve in these kind of services, and in what way. Finally, Hannah's presentation gave us a couple of cases that were very interesting, and I think my main learning from her presentation was that sometimes it's beneficial for a prison service to prioritize your target groups and to create some leverage, starting with a certain target groups, such in this case the sex offenders or domestic violence offenders. Now also, as I understand, including honor crime victims. And from that, you can sort of bring this question to the whole field or the whole range of victims. So that's also a way of bringing the attention to this question within your service. So thank you all for your presentations. It was very interesting. Thank you, Mirka, for the great moderation, despite the technical problems. And I would just like to again remind you, the participants, to fill out the feedback form. It's both to make it possible for us to improve future events within this platform, but also you can actually propose new topics for us. So for us, it's very important to get your input as participants on if the topics and the presentation and what is relevant for you to bring into this platform. With those words, I would like to close the webinar, and I thank you for your participation, and I wish you a good rest of the day. Thank you.